Consideration is some right or interest, profit, or benefit accruing to one party, or some forbearance, demerit, loss, or responsibility given, suffered, or undertaken by the other. This was taken from the case of Currie and Misa. A simpler definition is that consideration is the price of the promise, that is, what one contracted party is getting in return for his promise from the other. The seller suffers a detriment when he delivers the goods, and this enables him to enforce the buyer's promise to pay for the goods. An informal, gracious promise does not amount to a contract. A promise of a gift for sentimental motives is not binding on the promisor. Kinds of consideration. There's executory consideration, which is a promise to do something in the future. Executed consideration, which is an act wholly performed as part of a contract. And past consideration, that is something already completed before the promise is made, cannot generally amount to consideration. Traits of consideration. Consideration need not be aggregate. This means that the consideration provided by one party need not be equal in value to consideration provided by the other party. The consideration must move from the promisee. So a person to whom a promise was made can only enforce it if he himself provided the consideration for it. The act or promise will only amount to consideration if it has some economic value. And consideration must move from the promisee, but need not move to the promisor. While it is essential that the promisee provides consideration personally by conferring a benefit or sustaining a detriment in the traditional analysis, the consideration need not move to the promisor. Indeed, in the case of sustaining a detriment, nothing moves to the promisor. It is therefore possible for consideration to be purely a detriment to the promise. Types of consideration. Forbearance to sue. Promise to perform existing duty imposed by law. Contractual duty owed to a third party. Performing an existing contract duty owed to another party requesting extra payment. And part payment in settlement of debt. Part payment of a debt on the due date can never be satisfaction for the full amount owed because no consideration has been provided by the debtor to the creditor for promising not to claim the balance due to him. This is known as the rule in Pinnock's case. There are exceptions, however, to this rule, and these are accord and satisfaction. This is where the creditor requests payment on an earlier date, payment at a different place stipulated in the agreement, payment of a smaller sum accompanied by the transfer of another item. Another exception is part payment by the third party. So a creditor who accepts a smaller sum from a third party in settlement of debt is prevented from later claiming the whole debt from the debtor. This would be fraud on the third party. Thirdly, composition with creditors. A creditor is unable to claim the debt in full if an arrangement is made with other creditors in which they all agree to accept part payment instead of full satisfaction. An individual creditor would not be able to claim full debt. The debtor's consideration is obtaining the promise from each individual creditor to accept less than the full amount so that the creditor would generally share whatever property is available. Sorry, estoppels. The doctrine concerns promises not to enforce strict legal rights under a contract where the promise is not supported by consideration. In order to apply the doctrine of promissory estoppel, certain factors must apply. 1. There must be full, unequivocal promise by the creditor, as shown in the case of Central London Property Trust and High Trees House. Secondly, it must be inequitable for the creditor to go back on his promise. This implies that the creditor's promise must not have been extracted by threats or force, as in the case of D and C builders and REITs. Thirdly, the court may allow the creditor to rescind from his promise when the debtor's financial position improves. Fourthly, promissory estoppel is designed to suspend, not extinguish rights. And fifthly, promissory estoppels are a shield and not a sword, as demonstrated in the case of home and home. Past consideration. The general rule is that this is not good consideration, as taken from the case of Roscoe and Thomas, 1842. Good consideration in this regard is when the act is done at the promisor's request in lamplay and bootplate. Secondly, where it was expected that there would be a reward. And thirdly, where the agreement must be enforceable, otherwise the consideration, or but for the consideration question, as in Part 1 and Lao U law. Special situations affecting consideration. Firm offers. A firm offer is one containing a promise not to revoke it for the specified period of time. Such a promise is generally not binding unless the offeree has provided some consideration for it. So an offer on Monday to sell land for a particular price to be valid until Friday can be withdrawn on Tuesday. No consideration has been given for the promise. It is different if consideration for the promise has been provided. If the offeree pays or promises to pay for the time in which to accept, he is said to have purchased an option. Promises and deeds. A deed is an agreement in writing, under seal. To take effect as a deed, an instrument must make it clear on its face that it is intended to be a deed and must be validly executed as such. At common law, a deed required to be signed, sealed, and delivered. That's the end of this topic. Cases in relation to this topic will be found in the video description below.